Just a lot of feedback, sorry, I was looking at. So before we begin, I'd like to acknowledge that we are broadcasting from the lands of the Widjabul Waible people of the Bundjalung Nation. We pay our respects to their elders past and present, and also to any Aboriginal or Torres Strait Islander people joining the webinar today or watching the recording. Welcome to this Law for Community Worker webinar about coercive control. My name's Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. This webinar will run for an hour and a half and we're hoping that will provide enough time to answer a number of questions from the audience. After the webinar, you will receive an evaluation survey and we do value the feedback we get and try and plan our webinars around the topics that you request. Today's webinar is being recorded, so if for any reason you need to leave early, you can view it on the Legal Aid YouTube channel after it's been uploaded in the next few days. So now I'd like to introduce you to your presenters today, Sophie Anderson and Peace Decle. Sophie, for almost 25 years, has worked as a lawyer and advocate in criminal law and occasionally practices in employment law, discrimination and civil litigation. She started her career working with the Aboriginal Legal Service in Sydney and then in regional New South Wales. Sophie was called to the New South Wales Bar in 2014 and was the recipient of the Christopher G. Memorial Prize for Advocacy and Evidence. Sophie has previously lectured and tutored at Southern Cross University in Lismore. She's a current committee member of the Law Advisory Committee of Southern Cross University. In 2015, she was the runner-up in the New South Wales ACT Rural Women's Awards and actively mentors lawyers in regional areas. Sophie is also a member of the New South Wales Bar on the Criminal Law Committee and Wellbeing Committee and is a North Coast representative. She is currently a member of the Bugmy Bar Book Committee. Sophie also co-hosts a podcast, 5 Cases podcast, which is hosted by the Legal Aid New South Wales Criminal Law Division. Currently, Sophie practices from Lismore and does trial work, appeal work, and appearances in all courts and jurisdictions in New South Wales. Peace has been practicing as a lawyer since 2002 and was called to the bar in 2019. Throughout her career, the majority of Peace's practice has been in family law and child welfare law. Peace has a master's in applied family law, and whilst practicing as a solicitor, she was accredited by the New South Wales Law Society as a specialist in both family law and children's law as child representative. Peace has a particular interest in complex children's cases involving allegations of risk, particularly family violence and child abuse, and has extensive experience considering such cases from every angle of a dispute as she regularly acts and appears for parents, grandparents, foster carers, children, and the Secretary for the Department of Communities and Justice. Many of these cases involve concurrent criminal proceedings, giving Peace expertise in the crossover of children, parenting, and the criminal law. Peace has been involved with various boards in far northern New South Wales and is currently a member of the New South Wales Bar Association Family, Care and Adoption Committee and is involved with the Far North Coast Family Law Practitioners Association. Peace also teaches at Southern Cross University. So our audience, as you can see, our presenters are very well qualified to speak to you today about coercive control from 2 different perspectives. So welcome, Sophie and Peace, and I'll hand over to you now.
Thanks very much, Bridget. So if I can just start by giving everybody who's joining us a little bit of an overview of what we're hoping to walk you through today. We appreciate that our audience is very broad and that there are many people here who either work in the profession as lawyers or work in community areas that may have contact with various legal issues and clients, and that all of you are looking for practical information about how these laws might be implemented in New South Wales. So hopefully we're going to be able to cover that for you today. As Bridget has indicated, we have a slideshow for you, which will also be available. And just to give a brief outline of that, what we're going to do is cover effectively the legal aspects of it in terms of the background of the creation of this legislation, just touching upon what it is to do and what it won't do. So just looking at when it commences and looking at what it won't capture in terms of dealing with allegations or alleged offending which predates the legislation. And then also the next phase will be to look at the definitions of what is involved and sort of digging a little bit more deeply into the legislation. Now that might be a bit law heavy for some people, but if you can bear with us, we think it's important for people to understand the structure of the legislation, and we'll talk about some of the views that each of us individually have about how it will actually work in practice. Then we're just going to look at what some criminal defence perspectives, that's going to be me because that's my area of expertise, and then I'll hand over to Peace for some family law perspectives as well. We'll just look at some resources that hopefully will be of help to people watching, and then also try and address the questions at the end. So there's quite a bit to get through in the time. I guess we could dive in, so I might hand over to Peace now.
Thank you,
Sorry,
Sophie.
Can I just interrupt before you start? Some people are saying they still can't see the presentation, or either of you. Just to let the audience know, I have pinned you both, so you should be spotlighted for everybody. And my control panel here is showing that the slide that's headed Crimes Legislation Amendment Coercive Control Act is what's showing. Looks like I'm getting some thumbs up, so perhaps some people are just experiencing some technical issues. Sorry about the interruption. I just wanted to let the audience know that they should be able to view you.
Thank you, Bridget. So yes, we want to start, or we'll start the talk today, the presentation today, by talking about the Crimes Legislation Amendment Coercive Control Act 2022. Now, this is a piece of law enacted by the New South Wales government in 2022, which made fairly significant changes and brought the concept of coercive control into two areas of criminal law, one in relation to AVOs and the other in relation to creating a new offence. So this is where why we're all talking about this now, why we're all getting upskilled about what this all means. Important things to note about this is that the changes in relation to AVOs commenced as of February this year. So they've already been in place now for about 6 months. But the new offence in relation to coercive control commenced as at the 1st of July this year. Now, the significance of that is quite important. It only relates to behaviour which results in the offence of coercive control being met from the 1st of July 2024. So this act and this new offence will not be able to capture any behaviour by a person, no matter whether it falls within that definition of coercive control or not, that is prior to that date. So the legislation and the new offence are entirely forward-looking. Our screen just changed. Okay, all right, we're back. We're back. So very, very important for all of you to know, very, very important to pass so that the community understands that this is a forward-looking offence. It will not be used and cannot be used to charge people in relation to behaviour that was that was prior to the 1st of July 2024. Next slide, please. So what is coercive control? And I've put a definition here that's used by the Judicial Information Research System sorry, that's on that system created by the Judicial Commission of New South Wales. You'll see there, coercive control is a pattern of behaviour by which the autonomy of a victim survivor is eroded through behaviours that are psychologically, emotionally, financially, sexually or physically abusive, intimidating or violent. Now, the key to understanding it is that we are looking at abusive, intimidating or violent behaviours, and abusive behaviours fall in a number of different categories. And they are cases where they are not isolated instances, but fall within a pattern of behaviour that takes away really the ability of a person to make their own decisions about their life. For those that don't have a really or want to read more about coercive control, I would encourage you to have a look at the Domestic and Family Violence Bench Book, which is put out by the Australian Institute of Judicial Administration. It has extensive references to research about family violence generally, but in particular coercive control. Okay, next slide, please. Okay, so I want to talk about why this or how this legislation came to be enacted and why it takes the form that it does, because I think it's important to understand when we come to look at what the law is and what particularly the new offence of coercive control, it's helpful to understand what the background was to the making of the law. And this is a few points that come from the second reading speech by Mark Speakman that I just want to go through. The first one is that one of the impetus for this, looking at this legislation by Parliament, was the aftermath of the tragic homicides that we saw in Queensland. There was Hannah Clark and her children, and in New South Wales there was the Preeti Reddy, and there were coronial inquests into both of those murders, and each of them found that there was clearly identifiable coercive and controlling family violence between Hannah Clark and her partner or ex-partner at the time, and Preeti Reddy also. The second thing that had occurred prior to this legislation was there had been a domestic violence death review in 2019, and they did a deep dive into all of the cases of domestic or homicides that occurred in a domestic setting between 2016 and 2008 and 2016. And they identified that in all cases bar one, there was evidence of coercive and controlling behaviours by the person who murdered their intimate partner. And that's a very important piece of research. It is important to note in relation to that that's a correlation. It's not a causation. It doesn't tell us that the existence of coercive control means that domestic homicide is inevitable or even likely. But, and also there are many other factors that were also frequently present in each of those cases, including drug and alcohol abuse, mental health difficulties, childhood abuse, etc., etc. But it is still an important piece of research, and it helps understand why there was such an urgency on the government to do something about it. The Joint Select Committee in New South Wales ran specific hearings and consultations in relation to the issue of coercive control. That was very extensive over a period of about 18 months. It involved talking to frontline workers, talking to and taking submissions from people working in the legal sector, and also hearing from community members who were experiencing this particular type of family violence. And the result of that was this legislation. And you'll see that it was passed in 2022, but didn't come into effect until 2024. That was very deliberate. This is a fairly significant change to the law, and it was done to allow a number of things. The training of police is very important so that they understand coercive control and how to identify it and how to charge for this offence, but also the training of frontline workers and upskilling the community, educating the community so that they know what it is and can speak about it as well. And one of the important things to know about that process, that Senate Select Committee process, was that there was some really careful consideration of the way in which this law operates. And one of those aspects is that it was very intentional to only target at this stage intentional forms of coercive control. So they specifically considered whether or not this offence should incorporate recklessness or acts where someone is reckless as to the effect of their behaviour on the victim, and decided against having that as a one way that the offence can be proven, in preference for an intentional form. Couple of reasons for that are important to know. One is that there's not enough research, I think, is fairly accepted. There needs to be more research into this type of behaviour, and that is something that will occur after a period of time of this offence being in place. The other is that there was a real concern it might inadvertently capture behaviour that we don't intend or don't want to criminalise. So that is the way that the Act has been very deliberately created. All right, next slide, thanks, Bridget. Oh, sorry, next one again. Thank you. So this slide's just very brief. I'm not going to talk too much about it, but this is the Crimes, Domestic and Personal Violence Act amendment that occurred. What was amended in that act was the definition, and they created a definition of domestic abuse, which now incorporates, you'll see there, subsection B, coercive and controlling behaviour. One of the things that has been identified for, I think, many years in domestic violence research is that there's a lack of definitional consistency amongst different areas of law and in crime particularly, about family violence and what are we talking about. So one of the things that it's actually been recommended for quite a long time, I think back in 2010, the Australian Law Reform Commission and also the New South Wales Law Reform Commission both recommended that there be consistent definitions. It has taken quite a long time, but we now have across, in New South Wales, certainly in the AVO legislation, the new offence of coercive control, and also, we now have definitions that are very similar, and they match definitions that have been introduced in the Commonwealth setting. So family law has had a definition of family violence which incorporates coercive control for many years now. So they're relatively similar. So there's much more definitional consistency across these different jurisdictions and areas where we are dealing with abusive behaviour. So that's an important change and one that was quite deliberate. So I won't, if you can just change the slide, Bridget. This is the part of that definition in the AVO legislation. I won't go through it in any detail, but just to note that it is broader than the definition in the coercive control offence, but it is very similar, but it is broader. All right, move to the next slide. Thanks, Bridget. And the next one, that's just the end of that section. All right, so now we've moved to the Crimes Act, and this is the definition of abusive behaviour, which has been introduced into that division as part of the offence. It is all you need to know from this part is that it's a narrower definition than the AVO legislation. You can see there that it incorporates violence or threats or intimidation or coercive control. If you go to the next page, Bridget. And this is the subsection 2 is the part of the section which gives some content to being able to define what sorts of things might constitute abusive behaviour or controlling or coercive behaviour. Now, important to know about this subsection is that it's inclusive. So the following behaviour may constitute abusive behaviour. That means that it is not just going to be one of those things. It could be any other behaviour that doesn't fall within that list, which still is considered to be controlling or coercive or somehow abusive. So this is an inclusive definition. Just before we start going through some of those sections, it's important to know and to be mindful that abusive behaviour and whether it is coercive or controlling is always going to be highly fact-specific. Context is very important to showing whether or not this is abusive behaviour or whether or not it would be categorised in some other way. So evidence gathering and getting details and finding corroborative evidence is going to be always really, really important to show that context of what is alleged. Now, I'm not going to go through the whole list, but I'm just going to talk about a few of these particular subsections. Subsections 2 and A both refer to behaviour that causes harm. Harm is not a word that's defined in the Crimes Act, but if you look to the Macquarie Dictionary, that tells us that that can incorporate both emotional or physical injury in some way. That doesn't, that's very broad. It doesn't indicate injury can be temporary. It doesn't have to be permanent. So that's quite a broad definition there. It's got a wide range of scope of the way in which a child might be harmed by behaviour or a person might be harmed. Just looking at subsection A, behaviour that causes harm to a child if a person fails to comply with demands made of the person. An example of that comes from the Hannah Clark coronial inquiry. There was evidence that if Hannah Clark refused to engage in, for example, sexual intercourse with her partner during the relationship, that he would remove the children's toys or cancel outings that he had planned for the children. And that was something that she had spoken about as having an impact on her, and something that the coroner found was one element of a pattern of coercive and controlling behaviour, and the way in which he used the children to influence her behaviour and make her comply with his demands. Subsection C talks about behaviour that is economically or financially abusive. And again, this is incredibly broad, but one way in which that might be demonstrated is if a person is financially dependent on another person, then refusing to provide them with sufficient resources or money to meet their basic needs could be financial abuse. Examples of that could be, and I've seen this in my practice, a party, notwithstanding they earn their own money, the money and technically have access to it, having to check every purchase that they make outside of a pre-approved list of on what's on the shopping list, having to check and whether or not they're permitted to buy new pants or a toy for the child or something like that. That might be something that falls within the definition of financial abuse. It's important, though, to be careful when you're looking at allegations of, particularly of that type of behaviour. You need to be mindful of what is the capacity of the family. Are these abusive or unreasonable behaviours designed to control someone and prevent them autonomy, or are they reasonable measures that the parties effectively agreed to take because they have very limited resources, or they have a specific joint goal for saving? And this is part of a conversation about trying to keep their spending on track. So very important, again, context is everything, and evidence is everything to demonstrate this behaviour. Subsection E refers to behaviour that directly or indirectly harasses a person or monitors or tracks a person's activities, communications, or movements. This is the kind of, this monitoring and technological abuse is becoming more common. We're seeing a lot more in cases with people accessing other parties' emails, accessing other, personal information, particularly if they've had a shared computer or some kind of shared device and there are passwords, using devices, using Find My Phone, using the children's devices to monitor whereabouts, and those sorts of things. That is something that's definitely becoming a regular problem, a more regular problem. G, behaviour that prevents the person from doing any of the following or otherwise isolating the person. That includes making or keeping connections with the person's family, friends, or culture. An example of this is where a person may encourage their partner to reject their social supports, which are outside the relationship. And we do see that, with people who might, pick a fight with a family member, and then their partner is placed in a difficult position of knowing who they should support and feeling like they should support their partner, and pulling away from their family member. That might be an example falling within there. Again, important to look to the context and the detail, because there is a difference between someone who does that and someone, say, who might be supporting their partner who is having conflict with their family, and who might themselves be feeling like they ought to cease contact for their own welfare, for example. That is a distinction that can be fine and difficult to discern. So context is everything, and getting details and very detailed understanding of what's going on there to be able to show that this is actually part of a pattern of behaviour and not reasonable behaviour, which Sophie's going to get to in a bit later. Subsection I down the bottom, it's the last one I'll talk about. Behaviour that deprives a person of liberty, restricts a person's liberty, or otherwise unreasonably controls or regulates their day-to-day activities. There's a number of examples that fall within this. It could include not unwillingness for a person to be able to get a job outside of the home. It could be small things, locking the person out of their home after they've had an argument so they can't come back inside and access their things or get their phone or get their car keys. It could be more insidious, like checking the odometer of a party's car to see if they went where they said they were going to, and that being used as a way to cause a person to restrict what they do to avoid the anger and wrath that comes from having gone, done something outside of what the other person thought they should be doing. Okay, next slide, thank you, Bridget. And I will hand over to Sophie's now going to talk about the way that this particular section works, and I will come back in towards the end.
Yeah, thanks, Peace. Okay, so just a couple of things before we get into the legislation that I just wanted to touch upon, just rounding out some of the things that Peace was talking about. Firstly, in terms of this legislation, there are anticipated, or in fact there is in the legislation, designated judicial reviews of the legislation. As you heard Peace say, one of the aspects that was initially discussed in the construction of the legislation was whether or not the aspect of recklessness should be included. I won't go into the legal definition of that because it's actually quite complicated, but effectively one of the 3 scheduled ministerial reviews, which is due to be in July 2026 of this legislation, and is actually encompassed in section 54J of the Act itself. It's going to look at whether or not the mental element of recklessness should be included, because as some of you may be aware, some of you may not, but in other jurisdictions around the world, that element of recklessness is included in the offence. For example, there are differing opinions about how that works effectively or not, or whether in fact it captures what is otherwise innocent behaviour and criminalises it. So that's due to occur in July. Just for interest's sake, the other 2 aspects of the review are to include the maximum penalty, which I'll touch upon in a minute, and then also whether or not it should apply to relationships other than the current and former intimate partner relationships. Now, I noticed in some of the questions that we received, one of the, or quite a few of the questions related to whether or not this legislation would extend outside that intimate partner relationship that's been constructed, and particularly looking at things like elder abuse or the dynamics that exist in other familial relationships. And can I say that the way the legislation is constructed right now, it doesn't or isn't aimed or designed to consider those relationships. It is intimate based relationships, and its focus is that type of relationship. But obviously the review in July 2026 will look at whether or not it should encompass that. Can I also just say that in the second reading speech, if you are interested in looking at that at all on the Parliament website, Hansard obviously collects and stores the debates. There was quite a bit of debate about whether or not it should extend to other relationships. So there's obviously some people who are interested in seeing it extend to other familial relationships. The other aspect that will be reviewed at that time also is the impact of the offence on Aboriginal, culturally and linguistically diverse and LGBTIQ+ people, and whether victims are being misidentified as perpetrators. And that is a really serious concern in relation to this legislation, and certainly one that was raised a lot during the course of discussion in Parliament, and that is that people who are actually the victims of this kind of behaviour, in fact, might then be misidentified as perpetrators because, say, for example, the true perpetrator may simply just get to the police first and make a complaint. In any case, there's a lot of consternation about that issue. So they're they're the issues that are going to be part and parcel of the review. The last two I mentioned will be encompassed in the same part of the review. The other aspect that I also just wanted to touch upon before we dive into the legislation is that whilst there have been changes to the AVO legislation and the definitions that Peace took us through, and then the Crimes Act, there's now also changes to the Bail Act, which are important to understand. They came in on the 1st of July as well. And what that meant was that this legislation is now called or considered to be a show cause offence. And that has particular ramifications for people seeking to be bailed pending their court case being heard before a court. I'm not going to go into the bail laws because that's also a relatively complex area of law, but that's another significant change. So just turning to the slide now that everyone has before you.
Sophie,
yes.
Sorry to interrupt. People are just asking if you could speak up a little bit. I think the audio is slightly lower than mine.
Okay, hopefully you can hear me now. Hopefully I don't sound like I'm shouting at everyone either. But just looking at the screen in front of you, we're just going to go through those particular sections so that if you go into the Crimes Act, and just for those who are not people necessarily fluent in legal jargon, the Act that holds the definitions and information about this legislation can be easily viewed if you just go into Google and type in the name of the legislation which was on this slide. So you can see there then, and it will take you to these particular sections so that you can read for yourself what the definitions are. So you'll see here that the definition of adult and intimate partner is in section 54, capital C. And again, just referring to the fact that this is really quarantining the people who this legislation is sought to capture in terms of the nature of the relationship. And that is that the person is an adult and the person is an intimate partner. And the reason for those two distinctions, again, is that when this legislation was first being floated, there was consideration of whether or not it should encompass juveniles or people under the age of 18 who are engaged in intimate partner relationships. And it was considered that they should not be included. That's why those two definitions are there. And what that means is that even if somebody is relying on conduct which they say is coercive and controlling, once the person has become an adult, then those particular acts or that conduct really can't be relied upon as a proof element of the offence. The next provisions in terms of explanation of the offence, and we'll go through this in the next slide, but if we can just keep this one on now, is section 54, capital D, which actually sets out what the offence is. Section 54F sets out what abusive behaviour is. Section 54G, the course of conduct, as you've heard Peace refer to. This is a pattern of behaviour. One-off instances are not really sought to be captured by this particular law. And just on that, many of you will be aware that the Crimes Act in New South Wales captures so much conduct which is said to be criminal. And of course, all of those provisions continue. So if somebody assaults somebody or uses intimidation, then those crimes still exist and will be continued to be charged, particularly where they're single instances. This particular legislation, this particular offence is sought to capture a pattern of behaviour, and that's why that is distinct from those other offences that still exist and will continue to exist. Then I'm just going to look at the defences, which are in 54 capital E, and particularly the provisions within section 54 capital H. One, which is particulars of specific instances of abusive behaviour, and two, the standard of proof, because those aspects are very, very important. And as Peace has underlined in what she's talked to you all about, it's going to be in the detail. Something that is very important to bear in mind is that even if one person is convicted of a coercive control offence based on particular instances in a course of conduct, that does not mean that a person who, you know, acts in a similar way will also be convicted, because it all depends on the context in which it's occurring, and it all depends on the nature of the particular instances. So that is a very important aspect to bear in mind. Bridget, if you could just move on to the next slide. So 54D refers to the offence of abusive behaviour towards current or former intimate partners. The other thing about this legislation is that it is cross-jurisdictional, which is, I think, a first in New South Wales. There are some provisions within the Crimes Act that are extraterritorial, but this, where those provisions exist in New South Wales legislation, it is specifically legislated in the Crimes Act, and additionally it is confined to Australia. This legislation can in fact encompass acts that are said to have occurred outside the jurisdiction of Australia. So that is a very significant change in the legislation. So if somebody says, well, look, this event in particular happened when I was in Bali on holiday and this is what happened, then that evidence will be admissible. Whereas in many other, well, that's a first really, that evidence can be admissible in other ways in court, but it can't necessarily ground an offence in Australia. Now that particular act can be relied upon to ground the offence. But just turning back to section 54D and looking at that, it says quite plainly that an adult commits an offence if the adult engages in a course of conduct against another person that consists of abusive behaviour, and the adult and the other person are or were intimate partners. So you can see there that they are distinct aspects of the offence that the prosecution must prove. And the offender, sorry, I've just lost it away, and the adult intends the course of conduct to coerce or control the other person, and a reasonable person would consider the course of conduct would be likely in all the circumstances to cause any or all of the following, whether or not the fear or impact is in fact caused. And then it just goes through the two aspects there. And you'll see that the maximum penalty is 7 years imprisonment. Now, that is a very significant aspect of this offence. And I say that because by way of comparison, say, for example, somebody is charged under the Crimes, Domestic and Personal Violence Act in New South Wales of an offence of intimidation. That carries a maximum penalty of 5 years. Assaults, common assaults, carry a maximum of 2 years. So the fact that this offence carries imprisonment of 7 years is really suggests not only how significantly the Parliament considers the offending to be, and the need for people to obviously be deterred if they're sentenced in relation to the conduct. But it also means that when the court comes to consider whether or not the prosecution has proved its case, that obviously it will require significant consideration of each of these particular matters. The other aspect that I just want to reinforce in terms of the legislation is, of course, when the prosecution bring a charge of this kind, it is for the prosecution and the prosecution alone to prove that offence beyond a reasonable doubt. The standard of proof does not change, and that hurdle is a high hurdle for a reason. You've heard from Peace today that obviously this legislation largely mirrors what occurs in the family court, but there's no, obviously this legislation in the Crimes Act carries with it maximum penalties of imprisonment. So the test in terms of satisfying the offence in a court of law is still going to be beyond a reasonable doubt. For that reason, it requires that onus to remain. So it's important to just consider that. And as you heard me going through that legislation there, you might have thought to yourself, oh, this is a lot of provisions which require an and. So it's not an or. It's a very important aspect of this, that each of these 4 parts of the definitions in subsection 1 must be made out beyond a reasonable doubt, not, well, the person engaged in a course of conduct against another person that consists of abusive behaviour. Well, I don't really think it was abusive, but I think the rest of the things were there. So the intimate partner was there, or the intention, or what have you. It's very important to understand that the prosecution must prove each and every one of those elements. Thanks, Bridget. Could you just move on to the next slide? So just looking at element 1 there, as I've talked you through there, the accused must be an adult. Obviously, the adult commits the offence, and that is defined as 18 years and older. Thanks, Bridget. Next slide. Element 2 is of intimate partners. So the accused and complainant must have been intimate partners. Now, this is going to be a very interesting question, but the legislation has defined what that means, because again, when this legislation was being discussed, there was some consideration of what intimate partners means. So an intimate personal relationship, say for example, people are in a flatmate situation. Now, there has to have been an intimate personal relationship, and it does not require that that relationship was of a sexual nature. So the net that this legislation will capture, I think we will see in the future, will be quite broad, and there'll be a number of areas that are going to be tested about what is actually meant by intimate partners. But here you'll see section 54, capital C, obviously defines it as a spouse, so somebody who's married, or a de facto partner. People don't need to be married. They must have had or be in an intimate personal relationship, and as I said, regardless of whether or not that's of a sexual nature. Thanks, Bridget. Next slide. So elements 3 and 4, the course of conduct consisting of abusive behaviours. So again, the prosecution must prove the accused engaged in a course of conduct against another person that consists of abusive behaviour. We heard Peace briefly touch upon what that means before. The course of conduct and abusive behaviour are defined. So if we can just move to the next slide. The course of conduct, just looking at that specifically, so that's engaging in behaviour that is repeated or continuous, does not have to be an unbroken series of incidents or in immediate succession. So, for example, if somebody at Christmas time is behaving in this way, but then doesn't engage in that behaviour again until next Christmas, those instances could be relied upon to be repeated behaviour. So it doesn't have to be on Christmas Day, the 25th of December, and then again on the 26th of December, and again on the 27th of December. It can be broken up. And so that is designed to capture, obviously, a number of different types of behaviour. So again, just looking at the fact that the course of conduct can include in places in New South Wales or elsewhere. The course of behaviour or course of conduct may be a combination of abusive behaviours and assessed by considering the totality of the behaviours. So abusive behaviours, as we heard Peace define earlier, so say, for example, one of those abusive behaviours is financial control, then that may be the instance of that specific financial control can be relied upon. Then there may be some sort of other kind of abusive conduct which is relied upon. They do not need to be the same. They can be varying. And this is obviously where, in terms of the collection or collation of material and evidence, it needs to be specifically, well, obvious effectively or clear what the behaviour is designed to demonstrate. So if it's financial behaviour, that may be exposed through, say, for example, bank records, or as Peace was talking about before, the text messages about somebody having to seek permission to buy a pair of pants or something of that nature. But if it's financial control that's relied upon, and then also a form of intimidation or cultural control, where the person is then, again, in another instance saying, well, you cannot go to that cultural event because I'm saying that you can't, then there has to be some evidence of those two things. Again, it will be assessed by the totality of the behaviours. So, Bridget, if you could just move to the next one. Abusive behaviour is defined as violence, threats, intimidation, and that's defined in Section 7 of the Crimes, Domestic and Personal Violence Act. Interestingly, for us lawyers, perhaps everybody else as well, but coercion and control were not defined. Now, the legislative of Parliament had the capacity to define those two concepts, but chose not to, one would think, because they haven't defined them. So I think that is a little bit of watch this space in terms of what they will actually encompass. But so that's what the definitions of abusive behaviour include. And it says that abusive behaviour may be met by proof of behaviours in Section 54F2, noting that it's not exhaustive. So again, just repeating a little bit what Pete said before, it doesn't just have to be what is defined in the legislation. If you have a client that comes to you or a person that comes to you and explains to you conduct that you think is actually coercive and it's a pattern of behaviour, but it may not fit within the mould that's set by the legislation, that doesn't necessarily mean that it's excluded. It will be a matter of determination, I would expect, by a court ultimately. And of course, then Section 54H, in terms of the particulars of the behaviours said to amount to the course of conduct, must be provided by the prosecution. So particulars, for those people who aren't necessarily lawyers, particulars is just a legal word for detail. So again, just the detail of the behaviours. So that means more than one person's interpretation of the detail. It usually will mean some form of objective basis to demonstrate why a person has thought that the behaviour does mean an abusive behaviour. So say, for example, a person receives a card and that card is specifically, there's an example that was given by a prosecutor I heard where somebody was given a card of a cat on the picture on the front. Now, to everybody else, that cat may seem like it's a nice fluffy cat and it's a well-meaning card, but what the person who's receiving it knows is that their intimate partner killed their cat at a very specific point in a relationship, or killed their cat in order to control them, they say. And so the picture of the cat is actually used to remind the person who's receiving it of that event in order to act in a coercive way. So there needs to be the details, obviously they're the particulars of the behaviour would be, well, on X date I received this card and it had this content or whatever it is, and on X date my ex-partner or partner killed a cat and these were the circumstances. So the details and particulars of what it is in order to provide an explanation of why it's said that the behaviour is abusive. So Bridget, if you could just move to the next slide, thanks. So element 5 is the intention aspect. And as we were talking before about that recklessness aspect, this is where this would come into play in terms of the intention, whether or not it's deliberate or reckless. So at this stage, the offending must be deliberate. And what it says is that the accused intends the course of conduct to coerce or control the other person. So the accused intends the course. That is a requirement by the prosecution to prove that. And we've provided here what the court will look at. So the intention attaches to the course of conduct as a whole. And the Macquarie Dictionary provides those two definitions, noting that the legislation does not, as I pointed out before. So in terms of the proof of the intention, that is a requirement of the prosecution that they prove beyond a reasonable doubt the intention of the accused. Now, how do they do that? That's a very, I suppose, how long is a piece of string kind of question. but usually that is done by admissions. So say, for example, the accused might be captured on a text message saying, look, sorry, I stopped you going to that event. I know that your family is very important to you, but I just don't like you seeing your sister-in-law or your brother-in-law or whatever it is. I just don't think you should see them because I don't like you seeing them. So that might be an admission that the person has actually stopped them going to this event. Of course, when an accused person is, if they're to be charged with this offence, then of course they have the right to silence. They may be offered by police an interview to have the allegations put to them for their comment. And if they choose to comment, then anything that they say, as long as they have been cautioned in accordance with the law, would usually be admissible in a court of law against them, and that may contain admissions as well. In addition to that, another way that the prosecution may prove the proof of intention is through asking the court to draw inferences about the conduct. That's a whole other area of law that I won't go into, but they're the two ways effectively the Crown will need to prove the intention. So, Bridget, if you would kindly move to the next slide, thanks. So this is a very important aspect of this legislation, which is element 6, the reasonable person test. So a course of conduct is likely to cause, and then I've set out there, you can read for yourselves, fear that violence will be used against the other person or another person. And secondly, a serious adverse impact on capacity to engage in some or all of the person's ordinary day-to-day activities. These are what is required by the prosecution to be proved. So you can see there that this is quite a high hurdle for the prosecution to get over in order to satisfy the court beyond a reasonable doubt. And in terms of, you'll see the definition there that it must be likely in all circumstances. So what a serious adverse impact is on the capacity to engage in the person's day-to-day activities, again, will require evidence because it is not simply, say, for example, a reasonable person test. If a person, say, for example, the complainant or somebody who is defined in this legislation as a victim survivor, if they say to police, look, my partner was financially controlling me, he would prevent me from spending any money at all when I went to various places around, my local area. Now, if in fact that person has a gambling addiction and has had a prior conversation with their partner where they've said, look, I need your help. I can't do this alone. I need you to stop me spending money when I go into the shops. I can't help myself. I always end up at the RSL or wherever it is, and I end up, on the pokies. I need you to stop me from doing that. And that conversation obviously is very different to, or puts a different complexion on why the offender in that scenario might be coercing their partner not to engage in spending. Because the spending, when you drill down into what's going on, the spending may actually be spending in the RSL when they're playing the pokies. So it will be a reasonable person test, and all of this evidence, as you can see, will be tested or likely tested in the court to determine whether or not a reasonable person would consider the course of conduct likely causes these two things. So a serious adverse impact on the person's capacity to engage in ordinary day-to-day activities. In that example I've just given, if there is evidence that it is not a serious adverse impact for that person to be restrained from engaging in gambling where they are an addict, then of course that would mean that the prosecution had failed to establish that particular element as well, that the reasonable person test. The reasonable person test was added to the legislation to ensure, again, one of these safeguards that in terms of the identification of the actual perpetrators This is seen as being a safeguard to try and guard against the misidentification of perpetrators. So this is one of the aspects that Parliament considered to try and do that. Bridget, if you would kindly go to the next page. And then in terms of the legislation, there is this statutory defence. So as you can see there, it's legislated that it's a defence to the course of conduct if it was reasonable in all the circumstances. So like the example I've just explained. And once raised, the onus is on the prosecution to negative the defence beyond a reasonable doubt. So this is another additional hurdle that the prosecution must get over. So they've got to prove all of those things that I've just been through beyond a reasonable doubt. But in addition to that, if the defence or the defendant in the case, the accused person, raises, say, for example, well, no, I was just stopping my partner going to the pokies because she's got a gambling addiction, and we've talked about this, and she actually asked me, and we discussed that she needed my help, and so I am trying to prevent her from spending in this way, and that's what that was directed to. The prosecution must then prove beyond a reasonable doubt that that is not true. So it's an additional hurdle there to show that they can get across this defence. And that statutory defence, again, that was just an example. There will be so many different ways in which this legislation is actually applied to the factual scenario that the court is considering. But that is an example I gave you before. We might just move on to the next screen. So I'm just conscious of the time. And then there's the standard of proof. And it's very clear there that it all must be satisfied beyond a reasonable doubt. We've said BRD. Sorry about that, because as lawyers, we sometimes make acronyms assuming that everyone will know what we mean, but that means beyond a reasonable doubt. So it must be established by the prosecution beyond a reasonable doubt. You'll see there in B, individual instances that would otherwise be offences, and I spoke about this earlier, of assault, stalking, intimidation, do not need to be separately proven beyond a reasonable doubt. So in terms of the other offences, what you'll probably see with allegations that are put in the courts to determine these matters, you might see that coercive control is charged, and then there'll be a backup charge of intimidation or a backup charge of assault. And those particular offences will still run alongside the coercive control charge as well. But there are individual elements that must be satisfied by the prosecution beyond a reasonable doubt in relation to the offending, and just looking at all of that in terms of the course of conduct. So thanks, Bridget. Could you just go to the next slide? So again, this is, I suppose, probably a little bit more for the law junkies. It's a Table 2 offence, which means simply that when the prosecution charge this offence, it's an offence that can be dealt with in the summary jurisdiction in the local court, or it can be dealt with in the district court, which means a jury and a trial. So it's an offence which Parliament has deemed to be serious enough that it will find its way into the district court and into a trial court. It can be charged alongside other other sort of acts, as I've just indicated there. The double jeopardy rules apply to the conduct. So once the conduct is relied upon to make up the elements of the coercive control offence, if it is found to be proven, then the other charges, if it relies on the same conduct, would fall away. So a person cannot be penalised more than once for the same conduct. The provisions only apply to conduct, obviously, as we touched upon before, that relates to when the commencement of the division started. So that means conduct on the 30th of June 2024 will not be included. And then it's deemed to be a domestic violence offence on anyone's criminal record, which is important when it comes to considerations of bail and sentence, and also just identification of charges. and there is going to be an amendment of the Criminal Sentencing Procedure Act to allow victim impact statements. And I noticed some of the questions also were related to that. So how this legislation will feature in terms of the sentencing of offenders who are convicted of this conduct. You can see there that it will allow victims of the crime to provide a victim impact statement should they choose to do so. That can happen in the local court, but we more commonly see that in the district court. And the legislation has been amended specifically to provide for that. Thanks, Bridget. If you can just move to the next slide. Oh, so just going back to criminal law, criminal defence perspectives, as we were talking about before, this is sort of my opinion only, and I'm just going to caveat everything I say by indicating that that's the case. This is my opinion only. You've obviously got the law there. We've gone through it, and you can make your own judgments about the appropriateness of, say, for example, speaking to your own clients about whether or not the offence has been committed, or going to the police and seeking their advice, that kind of thing. My personal point of view, having been a criminal defence lawyer for almost 25 years, is that this is going to be a complicated offence for the prosecution to pursue. And I think there's a lot of community interest in seeing how these offences are prosecuted and what is successfully prosecuted, because there's quite a big distinction in what is actually prosecuted and what is successfully prosecuted. Of course, the information we're all very, the community is all coming to this with fresh eyes and fresh experience. What is important to understand is that this is a cultural shift in really trying to bring the community into a position where this kind of conduct is obviously identifiable and also brought to an end. And in terms of the shift of this kind of legislation, effectively, it's there to criminalise intentionally coercive and controlling behaviour, obviously, but it's now looking at really conduct which, to my mind, is going to require concrete evidence to prove. And I think that's going to be a significant hurdle for the prosecution. As some of you may have seen and may know, there's been people in New South Wales now charged with this offence or under these provisions. And I think many of those cases will generate, those early cases will generate a bit of publicity in terms of seeing what it looks like, how the prosecution are able to prove the offence. But I think there's a lot of work to do in terms of the prosecution being able to establish each of those elements and effectively to the test of beyond a reasonable doubt, which is high. So they're just a few perspectives I have. It is a real shift in thinking in terms of the legislation, in my view, and yeah, I'll be very interested to see what effect it has in the legal landscape. So that's my perspective, I suppose. Bridget, do you mind just going on to the next screen, and I'll pass back over to Peace.
Thank you, Sophie. As everyone can see, there's a real lot of detail in that new offence, and certainly from my perspective as a non-criminal lawyer, but someone who's kind of looking at criminal matters often, it seems to me that it's really going to be focused on the pointy end of that type of behaviour where, where it's very clear that somebody is intending to take away someone's, autonomy and liberty. And there'll be a lot of cases, I think, that people would think ought to fall within the offence that really won't be able to be captured because of the very technical nature of the offence and the very stringent requirements that have to be gotten over. But I just want to talk about what this offence means and also the AVO changes in terms of from a family law perspective. And again, this is just my opinion based on my experience working with family law cases where there are concurrent or have been criminal law proceedings involving the parties. And I think the big picture is I don't think it's going to make any dramatic changes in terms of the way that family law matters operate, other than this being part of the broader cultural shift that is happening within society. And I think that started in family law well before now, but having an offence is clearly going to fine-tune people's understanding, I think, and about the way in which their behaviour impacts others. So it's welcome from that point of view, and from the point of view of children who experience parents who engage in this behaviour. But in terms of how it will affect family law matters, big picture, I don't think it will make major changes, but I think there are some very specific ways in which it can or may have influence or impact those proceedings. The first thing is to say is, and I won't go into much detail, but obviously family violence is always a focus in family law. In parenting matters, I think the current statistics we have is that approximately 80% of all matters before our court involve allegations of family violence. And you'll note I use family violence. That's the definition in the Family Law Act. There is domestic abuse in the other in the criminal legislation, etc. We're talking about the same thing. We're talking about domestic or family violence. So it's a matter that is always considered in parenting matters, and it's also considered in property matters. Particularly in parenting matters, though, it's well recognised in our jurisdiction that particularly controlling and coercive behaviour can have extremely serious impacts on children, not just from directly observing that behaviour or experiencing that behaviour, but also by the impact that it can have on their primary carer. If their primary carer is experiencing coercive and controlling behaviours which are really impacting their ability to engage with the world and make their own decisions, that has an absolutely clear flow-on effect for children, and taken very seriously by our courts. But importantly, our definition of family violence, which incorporates coercive control, doesn't have all of those more stringent requirements that are in the criminal legislation. There's no reasonable person test. There's no requirements to prove intention or anything of the like. So the way that we capture family violence is incredibly broad, yeah. So in terms of the potential consequences that I can see, one, in relation to AVOs, I think it's likely that we'll see a broadening of the circumstances in which police will issue AVOs, protecting a parent or children. I won't go into much more about that, but I think that's likely to happen. The second thing I think that we may well see is, and this is common though for all criminal matters where there is a criminal law offence being prosecuted at either before or at the same time, is that it may well affect court timeframes. So there are quite strict court timeframes that the court likes to meet and works very hard to try and meet in the family law jurisdiction. But where there are current criminal proceedings for very serious matters like this, that may well be that will place pressure on those timeframes. There will be difficult decisions that will have to be made, and it may well delay finalisation of parenting matters in particular. The third thing is that it can affect the evidence that can be available in family law matters, where the court has in a criminal court has found an offence of coercive control proven, the evidence that was relied upon in that court, the findings that were made, if it was by a judge alone, or simply the outcome if it was a jury, are matters that can simply be adopted in the family law jurisdiction if they consider that that was appropriate. One of the things I think that's important when you're advising clients where there is perhaps they've been a victim of this type of behaviour and they're thinking about how they go about it is, the pros and cons of having these allegations dealt with in two different courts. There's that issue of the court timeframes that I talked about. If there's a criminal case pending, that may delay finalisation of a parenting matter for quite a long time sometimes. The other thing is, obviously, if a party's a complainant in criminal proceedings, they really don't have a huge amount of control over the evidence that goes before the court. They're not there getting to cross-examine the other party and try and get admissions or concessions out of them that might assist in proving that. That's very different in the family law court, where they absolutely would have that ability. Obviously, there's this difference in the burden of proof beyond reasonable doubt in the criminal court, but it's on the balance of probabilities in family law, and particularly for children's matters, doesn't even necessarily have to reach that high, because often what we're talking about in parenting matters, even if you cannot prove particular facts, the court still has to consider whether or not what evidence it does have raises an unacceptable risk of harm to a child, and that's something that's very typically under consideration in cases that involve coercive control. I think there's something that needs to be really carefully talked about if you have a client who's considering what their options, should they go to the police, should they deal with this in the family court. That's something that I think is worth having a very careful think through of all of the pros and the cons and where their case is, what are the advantages and disadvantages to them, and also particularly to the children of taking those options.
Thanks, Pete.
Thank you.
Can I just also address some of the questions that we had on some of those aspects? I just want to make very clear that this is not legislation that is designed to favour or capture conduct by one gender over another. It applies across the board and to people who are not necessarily identify in terms of a gender. So it is there to capture conduct by anyone in the community, and in terms of the implementation of that within the New South Wales Police, I know that there's been particular training. Obviously, we don't work for New South Wales Police, and obviously they would have their own protocols and be able to speak to this. But from anecdotal information that I've come across, there's been a lot of training that's been going on since midway last year, so some months. And there are obviously training of DVLO, domestic violence liaison officers, and also in terms of LGBTQI+ officers who are within New South Wales Police to assist people to come forward and determine whether or not there is an offence that has been committed. And also just in terms of general training of police who will ultimately investigate the matters, detectives, general duties police, and there's been a lot of training rolling out within the New South Wales Police system. So hopefully that assists some of the questions that have been asked prior to this session. I think more information on that would be within the New South Wales Police website, so it might be important to have a look there. In addition to that, sorry, Bridget, if you could just go to the next slide as well. We've got some resources for people to have a look at. These are more academic papers in terms of the ones at the end, but there are resources there for people who might be looking at the criminal aspects of it more from a legal point of view, and also the National Domestic and Family Violence Bench Book. In addition to that, there is a number of very helpful fact sheets which have been put out by the Australian government, by the Attorney General's Department. There's also been fact sheets put out by the New South Wales Government Department. These include the definitions of what coercive control is, how to recognise coercive control, how to respond, and then also specific factors to assist healthcare professionals to identify where there is coercive control, and contact numbers that people within those professions can contact, and the numbers all provided. But really, if you Google coercive control in New South Wales, what should come up is large portions of the quick reference guide, which looks a little bit like this, if you can see that page. But it is a government created document from September 2023, which sets out what coercive control is and how it can be identified. So there's extensive training going on across the state for police, and also within various legal spheres. So, of course, the Director of Public Prosecutions, Legal Aid, Aboriginal Legal Service, the private profession through the New South Wales Bar, through the Law Society, and within the court system itself. So all stratas of the legal system are being, education is being rolled out across the board in relation to how the provisions will apply. I think there are a lot of other questions, but if we now just go to the last slide. Thanks, Bridget. This is the part, Bridget, where we'll probably ask you to dip back in and see whether or not you can assist us if there's been any other questions.
Yes, there have been. Some I believe that you've answered during the presentation. There were a couple that related to whether evidence prior to the July date could be used, and you've made that clear that anything before the commencement can't be used. There's a question about in family law proceedings, what the position would be in relation to adjustment in favour of the domestic finance victim where there's a history of domestic violence, financial coercive control.
Yeah, thank you. That's a good question. So presently, the way the law stands is that if a court makes a finding in property proceedings that there's been family violence, and that family violence has an adverse impact upon a party's ability to make contributions, or the contributions that they have been made more difficult. And that can be in their parenting role, if they were experiencing, a whole range of family violence and coercive control, but also aggression, intimidation, whatever it might be, and they were having to parent and care for a child along the way, or if they were running a business and they were having to deal with someone engaging in these behaviours, and it was made their job all that more difficult. However it impacted them, that is a matter that the court can take into account when they are deciding what the adjustment, if any, should be of the property of the relationship. So that's already the law. There's a bill that's very recently been put before Parliament to amend the Family Law Act to codify that law. And in fact, it goes a bit further than what the case law had held. So it certainly is currently already something that can be and is regularly taken into account by the courts when making property adjustments, and it certainly looks very certain that it will be codified in law moving forward. So yes, but again, like anything, needs to be, the detail of explaining the way in which that family violence impacted on contributions.
Thank you,
Can I also
Peace.
just,
Yeah, go,
sorry,
Sophie.
back to that question before about whether or not evidence can be admissible before the 1 July cutoff or commencement. Just to be very clear, it doesn't mean that conduct that was happening up until that date won't be relevant, because it may be admissible through another door or another pathway in evidence, usually through tendency or coincident type of evidence. It just won't be relied upon to establish the elements in that offence. It might be evidence which is used as context to explain then the conduct after the 1st of July. So please don't walk away from this presentation thinking that, well, this was all happening to my client before the 1st of July and I can't use any of that information. That's not correct. You can absolutely use that information. It's just that it will form a different aspect of the evidence that may lead to the proof of the events that occurred after the 1st of July. It's a little bit complicated, but hopefully that's clarified that. So it can be used. It's just the way or manner in which it's used in proof.
Perhaps if you think about it as evidence which would give weight to a particular piece of conduct that occurs after the 1st of July. So you've got your pattern of behaviour which occurs after the 1st of July, and then you've got evidence of events that occurred before that date that would give weight to why you would perceive these new events or more recent events in the way that's alleged. Yeah.
Thank you. I just note the time, but I think we'll just go maybe 5 minutes over because we've had people ask questions sort of early on that have been waiting. So I hope that's okay with both of you. There's a question and I think some confusion about the reasonable person test. One person's asking, would that be one person's word against another? And what if the perpetrator says one thing and the other says no? I just wonder if you could just clarify what the reasonable person test means.
Yeah, so in terms of that, it's to answer that directly, if one person says one thing and then an accused person says another thing, it will be for the tribunal of fact. That is usually going to be a magistrate or a jury, so 12 members of the community, to determine whether or not they accept beyond a reasonable doubt the reliability and accuracy of the complainant. So it's not a test in that proposed scenario which is necessarily equally weighted in the consideration. But effectively, the reasonable person test is there to create objectivity. So it's there to, because what one person might say causes them to be intimidated might not be reasonable to another person. So say, for example, a person who's a very robust character may say, well, this person telling me that I looked horrible in this dress and that I, really shouldn't walk around in that kind of clothing, right? Some sort of imputation on that person. That person might be able to just laugh that off if they're a person that's of a robust character and it doesn't really worry them what another person thinks. But to somebody who may have other experiences or lived experiences in their life, which has meant that has a different meaning, then they may feel that really is something that is part of a pattern of behaviour which is done to coerce or control them not to wear a particular kind of piece of clothing. And that may not be the best example, but it's just one that I'm thinking of on the top of my head. And you can see by that it's going to require a lot of detail and understanding of the individual. Then you overlay that with the reasonable person test, which is to bring some objectivity from a third party, which is usually going to be a jury or the magistrate, to determine whether or not a reasonable person looking at that incident, whether or not they would determine that it is in fact done to coerce or control the person or not. So it's a very layered and complicated test. How it will work in practice, it's going to be interesting to see. I don't know that I can give anyone concrete examples of it because the test itself is an unusual test. We don't see a reasonable person test in nearly any other legislation. I think it's in some obscure environmental act actually, but it's not. It is in legislation, but not broadly used. And so how that applies in the real world is going to be really something we'll learn about as it comes. Sorry if I've just added to the
confusion. There's also a question about how will family court consider coercive controlling behaviour directed towards children, especially in circumstances when the children are telling the non-controlling parent?
Well, I mean, coming back to what I was talking about earlier, family violence is something that the court must consider, and safety there's something that the court is required to consider when it's making any decision about children. So there's no question that it will be considered. The question will always be what evidence is there? Does that evidence demonstrate that there is controlling coercive behaviour, and what impact is that having or likely to have or is at risk of having on the child? In terms of children and their views, that's a very complex area. And like everything in family law, and like I suspect the coercive control offence is going to be highly fact specific. So really does depend upon a whole range of other aspects of that child's parenting experience and the conflict, whether there's been conflict between the parents, what other features exist, etc., to be able to identify what weight should be placed on what a child might be saying to one parent or another parent about issues like family violence. But all I can say is that the court is specifically required to consider it in every case that it makes a decision about parenting matters. And the court is also required to consider things that children say. But again, it comes down to the weight that the court will place on those things, and that depends on what the evidence is, perhaps what children have said to other experts or other independent people, what the evidence shows about how well perhaps they're participating in school and other spheres of their life. So bit of a don't know that I've fully answered that, but all I can say is that they are certainly issues which are front and foremost of any decision about parenting.
I guess just to one last question before we wind up, there are more than that, but we're out of time, there's been a number of questions sort of asking to get an understanding of the sort of evidence that people working with clients might need to try and collect. And people have asked about, would a diary with incidents that are detailed in a diary be considered good evidence? You've talked about text messages. Just wonder if you have anything else to add to examples of what sort of evidence community workers might need to collect.
I could give a whole presentation on the gathering of evidence. Look, I think, and we always have to be careful when we're talking about gathering evidence. We're talking about, contemporaneous evidence which is contemporaneous to the events is often going to be the most persuasive. Evidence that's provided to independent third parties contemporaneously is always going to be given significant weight. So somebody who goes to a GP and reports what's going on at home, somebody who goes to a counsellor and reports contemporaneously what's going on at home, a child who reports to their school contemporaneously, all of those things. Text messages are, an incredible source of understanding the dynamics between two people. And I can't tell you, in fact, I'm mid-preparing for a trial at the moment, and I have 800 pages of text messages going back many years, which are illuminating to tell you about the dynamics where one person says, this is the dynamic, they were oppressive or whatever and coercive, and the other person says they're not, and the text messages they will tell objectively the story. And so thinking about all of those different objective contemporaneous pieces of evidence, I think, is a really good place to start when you're thinking about coercive control. And I just want to say, I don't want anyone to ever think my word about what I say occurred to me during the relationship is not enough. It is enough, and it can be enough. But when you're in a case where you have one person saying X and another person saying Y, and you have a judge in family law or some magistrate who is trying to form a view about which version of events is accurate, your version is always going to be assisted if there is some other independent, preferably contemporaneous evidence that corroborates what you say. So it's not that there are not cases where just simply what a person says has been accepted. That does happen, and it happens all the time, but your chances will be much better if you can look for and really think creatively about where else might be some evidence that supports what you say, even if it's not that you've reported to something, but that there are pieces of independent evidence which support the timing or support, other aspects of what you say in relation to your response to that. I went to visit my mother on this day, and that was because this happened. And you can show through the contemporaneous evidence that that's what you did. So
there'll also be complaint evidence taken by police. And this is one of the things I was trying to touch upon before with the upskilling of police in this area. They will not only speak to the complainant or the victim survivor, they'll no doubt also speak to members of their family or other witnesses who may have been complained to about the conduct in order to bolster what the complainant says. So just to underline there what Peace has said, don't think that just because one person says to police, look, he or she used to do this in our relationship, and gives examples, that will also be accepted. But it just means that when a court comes to consider whether or not it's reliable evidence, it's of course going to be aided where there is other evidence that supports it.
That's great. Thank you so much. Thank you to our audience. And there's lots of thank yous coming through on the chat and via YouTube as well, especially to all the work that the two of you have done in preparing the presentation. And I would like to thank you both for agreeing to assist us in the community legal education branch to bring this really important topic to community workers, because people have been requesting it for at least 12 months. So it's great to be able to finally be able to deliver that. And just to let people know, the handout was uploaded into the chat, and I have sent it by email as well. And if there are any unanswered questions, then we'll try and address those via email. So thanks everybody, and thank you for those who were able to stay on a little bit longer with us to hear the answers to those questions. And of course, this has been recorded and it will be uploaded to the Legal Aid YouTube channel in the coming days. So thanks to you both, and thanks everyone for joining us, and we'll finish the webinar now. Bye-bye.